Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can you sue the probation department? The short answer is yes, it's possible, but the long answer is that it is incredibly difficult and only happens under very specific circumstances. Probation officers are government employees, and because of this, they are protected by something called qualified immunity. This is a legal shield that protects them from being sued for doing their jobs, even if they make honest mistakes or use poor judgment. You can't sue your probation officer just because you think they're being too strict, you don't like them, or you disagree with a standard condition of your probation. The legal bar is much higher than that. The most common way to sue a probation officer or their department is for a violation of your civil rights, typically through a federal lawsuit known as a Section 1983 claim. This type of lawsuit alleges that a person acting on behalf of the government, or under color of law, violated your constitutional rights. So, what kind of conduct might rise to this level? Here are a few examples. First, malicious prosecution or falsifying evidence. This would be a situation where a probation officer knowingly lies in a report to the judge, fakes a drug test result, or plants evidence specifically to get your probation revoked. This isn't a mistake, it's an intentional act to harm you. Second, illegal searches. While being on probation means you have a reduced expectation of privacy, your Fourth Amendment rights aren't completely gone. An officer generally can't conduct a search that goes far beyond the scope of your probation conditions or is done purely to harass you. Third, excessive force. If a probation officer uses physical force against you that is clearly unreasonable and unnecessary for the situation, that could be a violation of your rights. And fourth, deliberate indifference or discrimination. This could involve an officer ignoring a serious medical need you have that they are aware of, or treating you more harshly and imposing different rules on you specifically because of your race, religion, or another protected class. To be clear, winning these cases is extremely challenging. The burden of proof is on you to show that the officer's actions weren't just a mistake but a clear, and often intentional, violation of established law. You will need significant evidence, not just your word against theirs. This means documents, emails, photos, witness testimony, or recordings if legally obtained. The single most important step you must take if you believe your rights have been violated is to contact an experienced civil rights attorney immediately. This is not a do-it-yourself project. An attorney can evaluate the facts of your case, explain the massive hurdle of qualified immunity, and give you an honest opinion on whether you have a viable claim. So while it's a tough, uphill battle, suing the probation department isn't impossible, but it's reserved for the most serious cases of official misconduct. Thank you for watching. If you found this information helpful, please hit that subscribe button and give this